like to welcome you to this morning's program, The President's Business Interests, Emoluments Clauses, and the Trump Administration. I'm Caroline Fredrickson. I'm the president of the American Constitution Society. As I think all of you know by now, or at least I hope so, ACS, which was founded in 2001, a pivotal year, is a national network of lawyers, students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. Seems like a very important concept in this particular moment. And ACS works for positive change by shaping the debate on vitally important legal and constitutional issues, such as the ones we are going to discuss today. Among the numerous ways in which the presidency of Donald J. Trump is unprecedented is the extent of his business holdings. Right now, there are 3 lawsuits pending alleging that President Trump has violated the Constitution's foreign and domestic emoluments clauses that are intended to prevent government corruption. We are very fortunate this morning to have lawyers and a litigant from all 3 cases to discuss the litigation with us. First, we are honored to hear from Karl Racine, who was first elected the Attorney General of the District of Columbia, is the first elected Attorney General of the District of Columbia and a plaintiff in the District of Columbia and the state of Maryland versus Donald J. Trump. Mr. Racine has broad and deep legal experience with a career that spans representing indigent residents in the DC Public Defender Service and volunteering as a law student in a clinic supporting migrant farm workers' rights, to serving as associate White House counsel in the Clinton administration. We'd like to say it was the first Clinton administration, but so far the only one. And practicing white-collar and commercial litigation with leading law firms. Mr. Racine was also the first African-American managing partner of a top 100 U.S. law firm, Venable LLP, where he led a team of over 600 attorneys. He's also served on DC's Judicial Nominations Commission, has a bachelor's degree from the University of Pennsylvania and a law degree from the University of Virginia School of Law. We are really delighted to have him as a friend of ACS and to hear from him this morning. So, General Racine.
Thank you.
Welcome.
Well, thank you to Caroline Fredrickson, Kara Stein, and the American Constitutional Society for the invitation to participate in this truly important discussion this morning. My job is pretty easy, right? I get to kind of glance and outline and kind of set the table, and then we're going to go to Joan to moderate what will be, no doubt, a very, very important and hopefully engaging panel discussion. I tend to like to start my speeches, particularly with lawyers, with a joke. Oftentimes it goes flat. I'm going to ask you to laugh regardless of whether it's funny. That's a deal. Okay. So, a surgeon, an engineer, and a lawyer were arguing about which profession was the oldest. The doctor said, well, on the 5th day of creation, God took a rib from Adam, so surgery's the oldest profession. The engineer said, but before that, God created the heavens and earth from chaos, so engineering is the oldest profession. And the lawyer said, yes, but who created the chaos? All right. We're here this morning to discuss a chaotic and I believe unlawful and unconstitutional situation that's certainly not being caused by lawyers, but instead is being caused by the President of the United States, Donald J. Trump. My colleague, and I do send his regards, Brian Frosch from Maryland, and I filed a lawsuit in federal court against the president because we believe he's creating an unprecedented constitutional crisis. Never in the history of this country have we had a president with the kinds of extensive business entanglements that President Trump has. And never in the history of this country have we had a president who has flatly refused to adequately distance himself from his business holdings. There was mention earlier in the introduction that I worked at the White House counsel's office. Well, I remember that time well because ethics and checks and balances mattered a lot. In 1997 through 2000, when I was there, in fact, we thought that there was a legal coup d'etat attempt that was going on by the independent counsel and by Congress in its numerous investigations. Nonetheless, there was checks and balance. We're here today talking about emoluments because the normal checks and balances, that is senior staff reining in a president, not working. The normal checks and balances, that is Congress, right, saying to the president, at least as far as the Foreign Emoluments Clause goes, hey, Mr. President, we have a say in this matter. We get to determine whether or not these emoluments you're receiving are appropriate. Well, that check and balance isn't happening. And so it's falling on, increasingly, the attorney generals. And let's be clear, it's been, unfortunately, almost in every exception, all the Democratic attorney generals. And so what have we done? We've organized in a way quite strategically to make sure that in addition to our daily important jobs of protecting our residents and certainly focusing on consumer protection and other things that attorney generals do, that we're also prepared to ensure that appropriate checks and balances are invoked. And oftentimes they get invoked by lawsuits where the federal judiciary will have the last say. And of course, we saw that in the travel ban litigations, that in my opinion, quite different from how the president's team discusses those suits. In a real way, the Attorney General from Washington, Bob Ferguson, Doug Chin, they prevailed. And they continue to litigate on issues as to what is a bona fide relationship. So that's what the Democratic AGs will do. Why do we have an emoluments clause? Let me refer to our nation's original anti-corruption law, the Emoluments Clause, and really quote Alexander Hamilton's words. One of the weak sides of republics, among their numerous advantages, is that they afford too easy an inlet to foreign corruption. Alexander Hamilton and many, many, many of the framers knew well that foreign sovereigns would seek to have undue influence on the United States and would frankly not stop at anything to have that influence. No better way to influence men and women in the world than by giving them things of value, even money. The framers knew that those were real concerns, and that's why we argue they drafted the Emoluments Clauses, foreign and domestic. Of course, in the District of Columbia, we know of a place of business that the president has, and that is the Trump Hotel. We also know very, very clearly from the words of sovereign nations and their representatives why it is that is the favored place to stay, to lounge and socialize, and to conduct business. It's because, and this comes directly from their words, they want to show the president respect, and they want the president to know that they have his back, at least when it comes to business. I want to really point out that the Trump Hotel and all that goes on there, literally every day, is significant because of how transparent and how flagrant the sovereign country's purposes and objectives are. But it's really important to underscore that the Trump businesses are incredibly opaque. And so while we might understand from time to time what's going on at the Trump Hotel, we literally don't have much of an idea whatsoever as to what's going on and who's conducting business and whatnot with Trump's businesses throughout the world. Therein lies the need for the court to come in and, as we're seeking, declare that the president is indeed violating the Emoluments Clause. And then we ask the court, in our prayer for relief, to ensure that the president puts in place a real regimen of separation to ensure no further emoluments. On that last point, let me emphasize that the President of the United States could cure this problem quite simply, literally, in a matter of days. Of course, he's got the finest talent, legal talent available to him, as is his right. Of course, if they really wanted to separate the president from his businesses, they could do that quite easily. And so it is incredibly important to note and emphasize that we're here not because the plaintiffs are edging for a lawsuit or, as I've heard, looking for publicity and notoriety. No, we're here because the President of the United States has decided and determined to do what no other president of the United States has ever done, which is flagrantly violate the Constitution, set himself up to profit wildly from folks who want to ingratiate themselves with the president. With that introduction, my job is to now sit down and let Joan do her magic. I should tell you that I'm going to have to leave sometime just a little bit after 10 in order to make a meeting at 10:30. But I do want to say thank you so much for inviting me. And again, I send regards from my friend and colleague, Brian Frosch. Thank you.
Thank you so much for that wonderful introduction, framing the issues, General Racine. So it is now my pleasure to introduce our moderator for today's panel. I think this is a very familiar name to all of you, the wonderful Joan Biskupic, who has moderated many a panel for ACS over the years. Joan is a CNN legal analyst and Supreme Court biographer, has covered the Supreme Court for 25 years and is the author of several books on the judiciary. Last year, Joan spent at the University of California, Irvine Law School as a visiting professor. And prior to that was the editor-in-charge for legal affairs at Reuters and a Supreme Court reporter for the Washington Post and USA Today. Joan is currently working on the biography of Chief Justice John Roberts, and we are all looking forward to reading that. She's a graduate of Georgetown Law School and was a finalist for the Pulitzer Prize in 2015. So please join me in giving a warm welcome to Joan Biskupic.
Thank you, Caroline, and thank you, Carl Racine, for setting the table as you wanted to do, and I actually even thought the joke was pretty good. Right. I just want to say, people always ask me, since Caroline mentioned the Roberts book, say, when's it coming out? And I always say, when I write it. So, so hopefully by the end of next year, that will be out there. But this is such a wonderfully timely discussion, and thank you for inviting me to moderate this. We have really an all-star panel. You can see in your materials more about their background, so I'll just be very brief now so we can get rolling on this. I also want to say that we're going to leave a nice chunk of time at the end for your questions because I can see many people who have followed this for a while and are interested in where these cases go from here. But first, let me introduce folks who are involved in the 3 lawsuits and countering them. And we're going alphabetically from our program, but I also want to make sure that I start, first of all, with Trevor Burrus for other reasons. He's a research fellow at Cato Institute's Center for Constitutional Studies, and he's researching, covers mainly con law and legal history. He will be offering kind of probably our strongest counter to some of these suits, since our other distinguished lawyers all have a hand in them. Then we have Brianne Garode, Chief Counsel of the Constitutional Accountability Center and the lead counsel for the case that's been brought on behalf of the members of Congress. Deepak Gupta, founding principal of Gupta Wessler, a boutique firm that specializes in Supreme Court litigation and appellate practice. He filed the first lawsuit on behalf of the Citizens for Responsibility and Ethics in Washington. Stephanie Litos is senior counsel to the Attorney General for Washington, D.C., and can also add flavor of that case, elaborate on General Racine's remarks. And then finally, we'll have Gautam Rao, who's an assistant professor of history at American University, and he's actually dug deep into the history of this area as a specialist in revolutionary America and the early republic. And he's also co-authoring a historian's amicus brief for the Crew case. So let's launch right in. And what I'd like the three key lawyers shepherding these cases to do as we start is to talk a little bit about your individual suits, how they differ from each other, maybe just give a distinction, some of the initial procedural hurdles, and what the audience should be watching for as these cases progress.
Sure. Well, thank you so much, Joan, and thank you, ACS, for hosting this great event. As Joan mentioned, my colleagues at the Constitutional Accountability Center and I represent nearly 200 members of Congress, led by Senator Richard Blumenthal and Representative John Conyers in their suit against President Trump for his violation of the Foreign Emoluments Clause. This is the largest congressional suit in history. And I want to let you sit with that for a moment because I think the number of members of Congress who have come together in this effort to hold the president accountable to the Constitution, to enforce the principle that no one is above the law, is really testament to the importance and significance of this issue and the importance and significance of the Foreign Emoluments Clause. You know, when our founders gathered in Philadelphia to draft our national charter, they were, as General Racine, mentioned, deeply, deeply concerned about corruption. They were deeply, deeply concerned about foreign influence. They were really worried that foreign governments might try to meddle in our nation's internal affairs. And they were worried that one way they might do that was by giving benefits and presents to our nation's leaders in an effort to subvert their loyalties. And so to guard against that, they adopted the Foreign Emoluments Clause, which very broadly prohibits any person holding an office of profit or trust under the United States from accepting any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state without the consent of Congress. I know we'll talk more about the history of the clause, the breadth of the term emolument at the founding, and so I want to focus in particular on 5 words in the clause that I think haven't gotten as much attention as they should in public conversations about the Foreign Emoluments Clause, and that are really critical to the Congressional emolument suit. And those 5 words, unsurprisingly, are the consent of the Congress. Significantly, the Foreign Emoluments Clause, while very broad in its scope, isn't an absolute prohibition. Federal officials can accept benefits from foreign governments if they first come to Congress, disclose the benefits that they want to accept, and get consent from Congress. And that's really key. That language was of critical importance to the framers. And the reason why is simple. They didn't believe that anyone should be the judge of their own integrity. And critically, the process of federal officials coming to Congress, identifying the benefits they wanted to accept from foreign governments, well, the framers thought that would ensure the sort of accountability and transparency that would help address the corruption concerns that gave rise to the clause in the first place. So disclosure was really key to the framers. But President Trump has not once come to Congress and sought consent to accept benefits from foreign governments, even though public reporting makes clear that he has been accepting such benefits. We know, for example, about the trademarks from China. An IP expert from Hong Kong said he'd never seen so many trademarks granted so expeditiously. We know about, as General Racine talked about, the diplomats coming and staying at Trump's hotel here in D.C. We know about foreign governments owning space and paying fees to Trump properties in New York. And critically, these benefits that we know about may only be the tip of the iceberg. The fact that the president hasn't come to Congress and disclosed these benefits and sought consent raises the really serious question of whether there are other benefits that he's accepting or wants to accept that he's also not disclosing and not coming to Congress about. And this really matters. I mean, again, the framers were deeply concerned about corruption. They wanted to make sure that when our nation's leaders acted, they acted in what they perceived to be the national interest and not their own personal financial self-interest. But because the president is not coming to Congress, because he's not disclosing the benefits he's accepting from foreign governments, Congress and the American people are left in the dark. And they're forced to ask about almost every policy this president takes, whether he's taking it because it's in the national interest or because it's in his own personal financial self-interest. And that is a really serious problem. The consent of the Congress language is also really important because it makes clear why members of Congress have standing to go into court to sue the president for his violations of the Foreign Emoluments Clause. That language textually gives to Congress a critically important role in determining what benefits from foreign governments federal officials, including the president, can accept. And the president, by not coming to Congress, not disclosing the benefits he wants to accept, is denying them the opportunity that, again, they're entitled to under the Constitution to grant or withhold their consent to the acceptance of these benefits from foreign governments. Members of Congress can't consent to what they don't know. And critically, there's Supreme Court case law and DC Circuit case law that makes clear that when members of Congress are denied an opportunity to vote, as they're being denied here, that injures them and gives them standing to come into court and sue. And so the relief that the members of Congress are seeking is very simple. They're asking a court to require the president to comply with the Constitution, to either stop accepting these benefits from foreign governments or to come to Congress, disclose the benefits he wants to accept, and obtain congressional consent. It's really quite simple. So we, as Joan mentioned, we filed this suit last month with 196 members of Congress. We'll be filing an amended complaint next month with additional members of Congress who also want to join in this effort. The government has indicated it'll be filing a motion to dismiss, as they've already done in the Crew case, and that'll be filed in September, and that motion will be fully briefed by the end of November. And so that's where we are.
Great. Thank you for laying out exactly the concern in Congress in exercising its own constitutional prerogative to oversee this area of the law. Deepak, you also have a distinct group of clients in yours, and you've amended it. So talk a little bit about the original complaint and then the fact that you brought on a booker and a restaurant opportunity center and why you did that. Thank you.
So thanks so much to ACS for organizing this and Joan for moderating. And especially, I just want to thank Attorney General Racine for the leadership and courage he's shown on this issue. It's no small thing for an official here in the District of Columbia to sue the president. So if you had asked me a year ago about the Emoluments Clauses, even though I practice constitutional law, I'm not sure I'd be able to have given you an intelligent answer. But after the election, in the months before the inauguration, I was part of a group of people who spent some time thinking about these clauses, and I found myself returning a lot to the Federalist Papers. And one of the things I always find amazing about the Constitution is the foresight that the framers had about all sorts of ways that the Republic could go wrong, even things that didn't come up for 200 years that suddenly do come up. There were a group of scholars, Lawrence Tribe at Harvard Law School, who's sort of always been my idol, the Dean of Constitutional Law, Zephyr Teachout at Fordham Law School, who has actually written a great book called Corruption in America and has actually written law review articles about the Emoluments Clauses even before Donald Trump. They got together with the two ethics lawyers for the last two White Houses, for the Obama White House and the George W. Bush White House, Norm Eisen and Richard Painter. And we teamed up with them and Norm and Richard's group, Citizens for Responsibility and Ethics in Washington, to bring this lawsuit on the first full working day of Trump's presidency on Monday, January 23rd at 9 a.m. And originally when that lawsuit was filed, the only plaintiff was Citizens for Responsibility and Ethics in Washington, which is a watchdog group. And Crew asserted standing based on a Supreme Court case called Havens Realty that gives organizations standing when they allege a violation of the law and they have to reallocate their resources based on that violation of law. And I think because of the way the lawsuit was set up initially with only that one plaintiff, much of the commentary, the lawsuit, much of the criticism of the lawsuit focused on Crew's standing. But Crew is not the only plaintiff in the lawsuit, and I think some people who have followed this litigation not as closely are not aware of that. We amended the complaint twice, as Joan mentioned, and we now have plaintiffs who are direct competitors with Trump's businesses. So let me just describe them for you. One of them is Eric Good, who is an owner of hotels, primarily in New York. He owns the Maritime, the Bowery, the Ludlow, the Jane Hotel, and he also owns restaurants, several of which are in hotels. And so these hotels and restaurants are in direct competition with Trump's businesses for both foreign and domestic government business. In addition, we've joined to the lawsuit a woman named Jill Phaneuf, who lives here in the District of Columbia, and she is a hotel event booker. And what she specifically does is she books events for hotels on Embassy Row here in Washington, the Kimpton hotels in particular. And her compensation is a percentage of the revenue that is derived from these events with foreign embassies. And so she is directly in competition with the Trump Hotel for business from foreign embassies. And there are diplomats who have said that they're moving their business to the Trump Hotel because they want to curry favor with the president. They want the president to think highly of them. If you go to the Trump Hotel, if you visit the bar there, you will see that there is a kind of apparent corruption premium. You can get a cocktail for $100 at the bar at the Trump Hotel. I'm not aware of other bars in the District of Columbia where that is happening. And so if you imagine yourself in Ms. Phaneuf's situation, you're talking to an embassy, let's say it's a Gulf state, and you want to convince them that they should have their event at your hotel. You're able to talk to them about what the ballroom looks like, how many people it can accommodate, what the catering is like, and then you're competing with someone who says, we'll be able to offer all of those things, in addition to which you will get the good favor of the President of the United States. That is not fair competition. That's precisely the kind of conflict of interest that the framers wanted to avoid, a situation where the President of the United States is profiting off of being the president for business with foreign governments. And then the third plaintiff that we added, so the fourth of the four plaintiffs, is called Restaurant Opportunities Center. And that's an association of restaurant workers and restaurants that are dedicated to raising standards in the restaurant industry. So the association comprises 25,000 restaurant employees and 200 restaurants, including some celebrity chefs you may have heard of. There are restaurants like Tom Colicchio and Danny Meyer. And so these are restaurants and restaurant workers that are in direct competition, again, with Trump's businesses, both in New York and DC and elsewhere. And again, they are competing with Trump for foreign government business, for domestic government business. And the reason I mentioned domestic government business is that in addition to the Foreign Emoluments Clause claim that parallels the one in the Congressional lawsuit, we have also asserted a violation of the Domestic Emoluments Clause, which I think you've heard mentioned, but maybe we haven't described. So let me just tell you what that is. The Domestic Emoluments Clause is in a section of the Constitution that defines the president's compensation. So what it says is that the president shall receive a salary, and that salary during the time that he's in office may not be diminished or increased. And the reason is that the framers wanted to protect the independence of the president, didn't want the president's compensation to become a kind of bargaining chip in Congress. And then it also, this is the emoluments part, says, and he, the president, shall not receive during that period any other emoluments from the United States or any of them meaning the states. And so he's forbidden, he gets the salary, and he gets that salary can't be touched. It can't be changed while he's in office. But he can't get anything else. He can't get any emoluments, any other benefits, payments from the United States government or from the states. And so if you look, for example, again at the Trump International Hotel, the lease on that hotel is with the GSA, a federal government agency. And so Donald Trump is sort of on both sides of that transaction. He's both the tenant, but he's also able to name the person who heads that agency. And when the agency made a decision, a discretionary decision, that they were going to basically look the other way, despite the provision in the lease that precludes elected officials from occupying that property, that was a discretionary benefit that came from the United States government to the president and benefited him personally and financially. And so that's just one example. If you just think about the same kinds of foreign government business that I described, but you think about states that are holding conventions, again, state officials may want to curry favor with the president. The domestic emoluments clause is also a problem given Trump's extensive and secretive business arrangements. So those are the plaintiffs in our case. Those are the claims. The relief we're seeking is a declaration that the president is in violation of these two clauses and an injunction requiring him to stop violating those clauses. And it's up to him how he chooses to respond, how he chooses to rearrange his affairs to come into compliance. As Brienne mentioned, this is the first of the cases in which the government has already filed a response. Despite Donald Trump's comments on the day of filing that the case was, in his words, quote, totally without merit, the Justice Department filed 70 pages of legal briefing going back to the framers, trying to find examples from the early presidents that they think provide counterexamples, particularly George Washington. That brief was filed on June 9th. We are in the midst right now of preparing the opposition brief, which will be due on August 4th. And the government, as we expected, has challenged the plaintiffs' standing, both Cruz standing as well as whether we have competitor standing. But they've also spent a lot of time in their brief taking a position on the merits. And what's really amazing, and it's worth taking a look for those of you who are lawyers, particularly at that brief, they take the position that it's perfectly fine for the President of the United States to be receiving payments and discretionary benefits from foreign governments. We think even on the test that they have announced, even on their approach, Trump has problems and we can show a violation, but we also think it's an incredibly cramped view of the clause, and I think we're going to hear that historians who are studying this disagree with their interpretation of the clause. So I'll stop there and look forward to the discussion.
Great, thank you. And we'll hear a little bit more about the administration's response as we go on. But, you know, it occurred to me, in your materials, I think you have the language of the foreign emoluments clause as well as the domestic one. But just in case anybody needs any reminder, it's in Article 1, Section 9, Clause 8, saying that the Constitution says, no person holding any office of profit or trust shall, without the consent of Congress, accept any present emolument, office, or title of any kind, whatever, from any king, prince, or foreign state. Now, Deepak just went through an explanation of his clients who feel like they are directly hurt by this. Stephanie represents people who are right at the scene. So why don't you talk about your clients here in the district and in Maryland and the different nature of the case?
Sure. So
I think you were on.
was I on? And I
Yeah, right. Okay, just press. There you
I'll
go.
do that again. Okay.
Great.
Not as experienced as the other members of the panel at using a microphone.
You're okay. You're fine.
So I represent the District of Columbia, and along with the state of Maryland, we filed suit on June 12th against Donald Trump in his official capacity. And some of our lawsuit is similar. We're making some similar arguments to some of the arguments that Deepak just spoke about. Specifically, the competitor standing argument is similar in that we are arguing that both the state of Maryland and the District of Columbia own or operate properties that are direct competitors to the Trump Organization properties here in the district. And so therefore, competitor standing is a similar argument to that which has been brought in the Crew lawsuit. But however, we also think that we've brought claims that are unique to the District of Columbia, and to the state of Maryland. And so we think that we have standing for some reasons that are specific to the fact that we are government entities. And so specifically to that end, we have an anti-competitive argument that we are making. So essentially saying that in our governmental capacities, we have the responsibility to protect the residents of the district and of the state of Maryland, and that part of that capacity is making sure that we have a level playing field when we're talking about competition. And because the Trump Hotel is in the district, it has created an anti-competitive environment. And with the huge hospitality industry and tourist industries that both the district and the state of Maryland enjoy, we have a special ability to sue on behalf of the residents of our government, of the district and of the state of Maryland to enforce that. Additionally, we are bringing a domestic emoluments clause claim, and Deepak has ably discussed the contours of the domestic emoluments clause. But one of the reasons that the framers created the domestic emoluments clause was to make sure, again, that there was no corruption, but to really make sure that one state wasn't able to try to curry favor with the president at the expense of another state. And so what the states didn't want, especially at the founding of our country, was states kind of banding together for their personal interests, giving the president some type of gift or emolument, and then getting the favor of the president and getting more favors from the president. And so what we're seeing here is this is kind of coming to a head now, where you have a president who has huge business interests throughout the United States, and you don't want to be in a position where one state feels the need to give the president some type of concession, whether that be tax breaks or licenses that he might not otherwise have been entitled to receive. You don't want one state being compelled to do that so that they can get some kind of favor from the president. And so as governmental entities, again, we think that we have unique standing here in order to make that argument that the states and the districts should not be put in a position that they are essentially trying to gain favor with the president. And it's important because we've heard recently that the president has announced, or the Trump Organization has announced, that they are going to try to open up a new line of hotels, kind of a lower end hotel throughout parts of the country that were specifically parts of the country that were states that voted for Trump in the election. And you can imagine a situation when they're doing that, there are going to be a whole lot of licenses and tax breaks and other regulatory hoops that they have to jump through in order to set up those hotels. And we don't want to be in a position where one state is being favored over another simply because a Trump hotel is in that state and they've decided to give the Trump Organization a very large tax break, for example. And then additionally, Maryland has its own unique argument. And unfortunately, we don't have anyone from Maryland here, but I will speak to it just briefly. Maryland is arguing additionally that it has a specific sovereign interest in the Emoluments Clause being enforced because before Maryland became a state, it had its own constitution, which had its own Emoluments Clause. And so Maryland is arguing that as an inducement to enter the United States, there was an Emoluments Clause in the U.S. Constitution, and that clause is now not being enforced, and Maryland has not given up its right to make sure that that clause is being enforced. So those are some of the ways that our lawsuit differs from the other lawsuits. We additionally, and similarly to the other litigants, are asking for a declaratory judgment that the defendant is violating the Emoluments Clauses, and then relief that he would no longer violate the Emoluments Clauses. And as Attorney General Racine said in his opening remarks, what that looks like is still an open question, but it is also the case that the president could decide voluntarily that he wants to separate his business entities from his work as the president, and that this could be resolved. Whether that happens, we will have to wait and see. And then in terms of timing on our case, we filed very close in time to the Congressional lawsuit, and so currently the Department of Justice is seeking to have until the end of September to file a motion to dismiss in the case, and they have indicated that they intend to file a motion to dismiss, and then the briefing will continue from there.
Great, thank you, Stephanie. Trevor, why don't you talk about some of the hurdles these cases could face in terms of standing, how difficult it is to sue the president, and what we've seen so far in the administration's response. Just give us a little flavor of that, and then we can mix it up throughout the rest of the discussion.
Thank you. Thank you to ACS. Thank you to Joan. And I like being on these nice balanced panels where I have all the others. If you're a con law geek, like I think all of us are, this is a great time. It was also a great time in the Obama administration. States are just constantly suing the president. They did it in, excuse me, they did it in the Obama administration, and they're doing it now. And of course, the Emoluments Clause. I mean, when that first came across my desk, I was like, whoa, this is good. I look forward to future events about the Tonnage Clause and other obscure parts of the Constitution. I want to be very clear, by the way, that I disagree with the substantive argument that this violates the Emoluments Clause, but I am not a Trump fan, to say the very least. Like, Cato is at the forefront of many fights against Trump, including on the immigration executive orders. I am not defending Donald Trump, okay? Please, everyone understands this, okay? But I do not think that using the Emoluments Clause in the way that we're trying to use it here is both wise or actually a proper reading of the Constitution. It's not wise because I think that going after a sitting president who did win an election with something that will be seen as a technicality and especially a theory of any benefit, in the words of the tribe paper and the suit, that theory will be seen as a coup. And so, General Racine, you said that it was a coup in the Clinton administration, and it will be seen as a coup here too, as opposed to other things we could be putting our effort to try and stop Trump from doing things like actually getting Congress to fix the problem. Now, why don't I think the Emoluments Clause applies here? First, perhaps weirdly, but if you look at the actual evidence on it, the Emoluments Clause, the Foreign Emoluments Clause, does not apply to the President of the United States. This may sound absolutely ridiculous, and if you take a view that is often taken by Brianna and people at the Constitutional Accountability Center and Zephyr Teachout's anti-corruption principle view generally, which is a strange form of originalism that basically says the anti-corruption was the biggest thing that they were trying to pursue, was one of the biggest things, and everything that is possibly corrupting, including the First Amendment and campaign finance, should be interpreted as anti-corruption as being the overarching view of the Constitution. So how could they possibly exclude the president? Well, first of all, just on a textual commitment level, the phrase under an office under the United States throughout, as it was understood at the time, as the clause says, does not apply to any elected member of the United States. It actually, the people who are elected into the government are constituent parts of the government. They don't hold offices under the United States, which are appointed offices, and those people are who the Emoluments Clause applies to. We have much evidence for this, and this was the understanding of the time. First of all, the phrase under the crown, in the Anglo tradition that the framers were coming out of, the phrase under the crown never ever meant anyone in serving in Parliament, for example. It meant people serving under the crown appointed by the Queen. They still use this today in the UK. In Australia, they say under the Commonwealth. That does not include federally elected Australian members. So we have this basic textual commitment there. Secondly, we see practices of the time. The kind of broad sweeping idea of that every sort of benefit that could be an emolument. I'm just interested in what is an emolument. And I think that the broad reading is a problem. And if it were true, if they thought it was any benefit at the time, and if they thought it applied to the president, then George Washington would have violated it sometime within the first 6 months of his administration, and continually and willfully and knowingly violated it himself when he purchased land in the Capitol, when he took a large picture of Louis XVI, which is still on display at Mount Vernon, when he took the key to the Bastille as a gift from Marquis de Lafayette, which he did not ask consent sent from Congress for. Same with Jefferson. He willfully and continually violated the Emoluments Clause. Apparently, when he took a large bust of Tsar Alexander I for Russia, actually every gift from the Lewis and Clark expedition, if we considered the foreign nations that were Native American tribes, they were counting and bringing gifts back to him. Every single one of those was a violation of the Emoluments Clause. President Madison would have violated the Emoluments Clause, but President Madison then gave some pistols to President Monroe, which would have violated the Emoluments Clause under this interpretation. Or we could believe that Washington was a deeply principled man who took the obligations of his office and the corruption and the perception of corruption very seriously, but did not think that A, either the clause applied to him, or B, these things were emoluments, which is the second part of this problem. What is an emolument? I mean, I'm sure before today, everyone used that word in their daily life, right? It was like, hey, doing salary negotiations, what's the emolument here? What am I going to get from my emolument? No, you did not. But it's all over the Constitution. It's actually in a different place in the Constitution, too, usually called, aside from the domestic Emoluments Clause and the foreign Emoluments Clause, it's called the legislative Emoluments Clause, or the ineligibility clause is usually what that is. And that refers to the fact, it's kind of like the 27th Amendment, actually. It says that you cannot, no member of Congress can be appointed to a different office of which the emoluments have been increased of that office. And they're clearly referring to the compensation given for the office. This came up when Hugo Black was going to go from the Senate to the Supreme Court, and in the time that he was in the Senate, they had raised the pension of the Supreme Court. So there's a question about whether or not that pension itself was a raising of the emoluments of the office. But when we started looking down, it's not any benefit. It's not any benefit that accrues to Trump's businesses. If that's true, then the fact that Mount Vernon was a working tobacco plantation for the entire Washington administration and maybe occasionally sold some tobacco to, I don't know, like the French foreign official, or sold tobacco to the government, or possibly the fact that some foreign official bought a copy of The Audacity of Hope from President Obama, that would be any benefit, right? That'd be an emolument under this broad definition. No, what an emolument is it's kind of compensation in exchange for doing the duties of office. So if the president were to become a paid member of the Australian government, a consultant to, I don't know, consult on how to make reality shows or something like that, that's the kind of thing an emolument is. It is not merely a benefit that you get from office. I think fundamentally, if you look at the debate between Zephyr Teachout and Seth Barrett Tillman, who was the first to kind of write about how this doesn't apply to the president, which again, I want to point out that it's not as weird as it sounds. The idea that the president is checked by the electorate, but appointed people would not be checked by the electorate. We have a federal code of ethics, of judicial ethics, that applies to every single federal judge in the United States, except for the Supreme Court. You would be like, this is amazing. How could we possibly, we said the only judges who can be unethical are the Supreme Court. Well, no, the reason we have that is because of the apex people in the political system. If there was a federal rule of ethics that applied to the Supreme Court, that would basically be the Supreme Court eventually. So it does not apply to the top people. Often this is true. So we have to think about political controls, different ways of, they can impeach for any reason they want. Different ways to do this politically. One last point about offices under the United States. In 1790, there was I can find the exact language here, there was the federal bribery statute was passed, which said that any defendant convicted of bribing a federal judge shall forever be disqualified to hold any office of honor, trust, or profit under the United States. If this would be the case that someone had been convicted of bribing a federal judge, and then therefore, if that meant the presidency under the United States, then they could not run for president. This means that they added to the qualifications of the presidency beyond what the Constitution requires of the qualification for presidency. There's a lot of things that get weird if you apply the Emoluments Clause in the way it's being applied and to the president. Standing I can get to later, but actually there's so many different versions of standing here. I mean, everyone has a different standing issue here. But I just wanted to put that up there to begin with.
That's great. Thank you for answering any concerns about balance. Perfect, yeah. Okay. Okay, now Gotham, who actually is the real historian on the panel, but who, as I said, will be submitting an amicus brief on the side of Crew. He's been down in this deeply way before many of us even started paying attention to the Emoluments Clause. And what will matter here? And maybe how is Mount Vernon not like what we've got today? So take it away. Thank you.
Thanks. It's great to be here. I wanted to point out first, I'm co-authoring this historian's brief with some people who are far more talented than I am, so I wanted to mention them. It's in particular John McHale of Georgetown Law Center, Jed Sugarman of Fordham Law School, Simon Stern of the University of Toronto Law School, and the legendary historian Jack Rakoff of Stanford University. So our position on this brief is we avoid some of the thorny legal particularities around issues like standing and really hone in on the historical meaning of emolument as it occurred to the framers. And we try to do so by looking at the context before and after, and also to provide the court with a sense of how scholars have understood some of the big questions here over time. I'll break down what we're trying to do here in a few parts. We each have, each of the co-authors of this brief is taking a kind of chunk. Jed Sugarman is handling the question of the office under that Trevor was discussing just now. And he has pretty compelling evidence that would completely disagree with what Trevor just said about whether or not the presidency is an office under the Constitution. And he is looking at state constitutions and many, many, many other documents to make that case. Simon Stern and John McHale are looking at the historical meaning of the word emolument itself and whether or not it has the extremely particular meaning that the president's attorneys seek for it to have, or whether it meant something more powerful and was more injunctive, and they certainly fall on the latter of those two. They also look at the great treatise writers, people like William Blackstone, and how they're using the term. Jed Sugarman and I published a piece in Slate a few days back that attempted to respond to Seth Barrett Tillman's argument that Trevor's raised here again today on several different fronts. I won't go through the particulars of it. You can take a look, but I just wanted to address one part of it, which is something that is a compelling force for me in my own work. It's the idea that if the founders did something, or the framers did something, that therefore it is dispositive in a legal sense, or therefore that we should do that same thing. And I think history can be a very dangerous thing if you're going to use it in this way, because the founders, framers were humans. They made many mistakes, among them continuing the enslavement of many million people. And to simply look at their example of behavior and use that in a dispositive legal sense, I think is a fairly dangerous thing to do. The courts have typically not done that in this country either. But as a historian, that's something that strikes me as a very important problem with the argument that the president's advancing. So I'll leave it there. I know we have a lot of Q&A to get to.
Right. We'll just do a couple questions, and then we'll take yours in probably, 10 minutes we've got left to get into that part. Thank you all. You know, I'm wondering just where the judges will look initially. Let's set standing aside, because I think everybody agrees that that'll be hashed out, and the most interesting part is exactly what does constitute an emollient, and what would any remedy possibly look like. And one of President Trump's lawyers had said, Sherry Dillon had said, no one would have thought that when the Constitution was written that paying your hotel bill was an emolument. Now, the administration's response in the Crew case that came in last month obviously talks a lot about Mount Vernon and what early presidents at the founding of the Republic had. Where, Breanne, let me start with you. Where will judges look beyond just the history of the Constitution, how it was written? Are there any cases that could illuminate this in any way that you think are particularly relevant to point out to people?
I mean, I think the judges will be looking principally at the text of the Constitution, the history of the Constitution, and what was going on at the framing. I mean, there's not really case law interpreting the Foreign Emoluments Clause, the Domestic Emoluments Clause, in large part because, presidents before this, federal officials before this, have gone to great lengths to avoid violating both of those clauses. And I want to respond briefly to Trevor's assertion there's something strange in this idea that the framers were deeply concerned about corruption, because it is something that Zephyr Teachout has written about at great length. It's something that my organization, the Constitutional Accountability Center, had written about in the campaign finance context long before Donald Trump was elected president. And it's just not right. I mean, if you look at the framers' deliberations, if you look at the Constitutional Convention, the framers were positively obsessed with corruption. They had seen what had happened to other governments that allowed themselves to be corrupted. And so they talked about corruption constantly. It was a topic of conversation nearly a quarter of the days that the Constitutional Convention met. George Mason warned his fellow delegates, if we don't guard against corruption, our government will soon be at an end. And so it's not at all surprising that they would then have included in the Constitution, as they did, multiple guards against corruption, the Foreign Emoluments Clause and the Domestic Emoluments Clause being two chief ones. And that's why this idea that the Foreign Emoluments Clause is somehow a technicality, I think just gets it totally wrong. It was a fundamentally important anti-corruption principle. It was important to the framers, and it's critically important today. And I should just say this idea that this is some kind of coup. No one here is asking for a court to remove President Trump from office. All we're asking for is that he comply with the Constitution. And as we've all said, there are different ways in which he can do that. He can divest from his businesses. He can, with respect to the Foreign Emoluments Clause, go to Congress, as the Constitution specifies, and try to get congressional consent. And then, to this question of materials to look at, I think the work that historians are doing is incredibly important. John McHale, for example, has just posted an incredibly important article in which he looks at, the ways in which the term emolument was used at the framing. I mean, it's true, the word is fallen out of common usage. I'll admit I don't use it on a regular basis. But at the framing, people did use it. They used it all the time, and they used it to refer to a wide variety of different types of benefits, including ones that represent the kinds of fair market value exchanges that we're talking about now.
Yeah, let me ask Deepak to.
I just want to clarify. I didn't say they weren't concerned about corruption. I just said that I agree that they were. I think they were concerned about many things, including corruption. And so, interpreting something as corruption as the overarching principle by which we should interpret certain things, I don't think that is the case. And I think that they would have said, well, no, the people can be aware of the gifts that the president is getting, and they can vote him out. And that's a check on corruption, too.
But one way they know about it is by going to Congress and disclosing this consent, and that's what the president is failing to do.
If it is an emolument. But I also don't think the Emoluments Clause is a technicality. I think it will be perceived as a technicality.
Yeah, and Deepak, let me follow up on that with you, because what I'm looking for is, in terms of thinking about the remedy and thinking about where else these arguments can be illuminated beyond the deep history. What example? Blind trust, is that the main thing a president could do in this kind of situation?
Yeah, I mean, let's remember Jimmy Carter had to sell his peanut farm when he became president. It's not unusual for all sorts of high-level officials to take extraordinary steps to divest themselves of their assets to remove conflicts of interest, and we have a government office that's charged with ensuring that occurs. The Office of Government Ethics, and they seem to have had a kind of nervous breakdown over Donald Trump. The unusual thing here is the way in which Trump has just defied any kind of norms surrounding conflicts of interest. We're not the ones that are sort of raising this technicality, out of the blue, and I want to emphasize that this is not just some esoteric technicality that we're raising for the first time. One of the other places that the courts can look, in addition to the amazing research that John McHale has done about the historical legal dictionaries from the 16th century to the 18th century, and what the framers had to say, another place to look is the significant body of precedent that has accumulated within the federal government. The Office of Legal Counsel at the Justice Department has been interpreting this clause for over 100 years. When Barack Obama received the Nobel Peace Prize, lawyers in the White House counsel's office and the Justice Department's Office of Legal Counsel thought it was a serious enough question whether or not he could receive the money attached to that prize. And so they wrote a legal opinion. That legal opinion, by the way, concluded that surely the President of the United States is covered by the Foreign Emoluments Clause. So that's
Surely.
Well, that's the position, I mean, that's the consistent position of the executive branch. It was also, by the way, the position of Trump's lawyers. Trump hired the Morgan Lewis law firm to represent him on this issue. That was Sherry Dillon that Joan mentioned. They held this press conference. Do you guys remember the press conference with all of the folders where he said he was divesting himself? We think those folders are probably empty. But at that press conference, they put out a 5-page white paper attempting the first defense, legal defense of Donald Trump and his Emoluments Clause violations. And even the private lawyers hired by Trump took the position that the clause applies to the president. So his private lawyers are taking that position. The Justice Department in the litigation are not contesting that the clause applies to the president. They're adhering to executive branch precedent on that score. And there's a consistent body of precedent. So I think that's another thing that the courts will be able to look to. And I think what that shows, and we're going to have an amicus brief, in addition to the historian's brief, there will be a brief by former government ethics lawyers who will show the court that this is an administrable scheme, that if you're a retired military officer and you take a job teaching in your retirement, you're continuing to receive retirement benefits, you're still considered an officer within the meaning of the Foreign Emoluments Clause, and you can't take money from a foreign government. So those kinds of rulings are being made all the time in the executive branch, and it shows that the clause is administrable and isn't some kind of technicality. And just one last point, echoing something that Professor Rao said, when we think about what the First Amendment means, we don't look to the Alien and Sedition Acts, right? Some of the framers, they made some mistakes, and constitutional law evolves. I think a much better place to look would be the body of executive branch precedent actually interpreting these clauses.
Yeah, go ahead and respond.
Yeah, I think that it's true that a couple points. There are many definitions of emoluments in the founding era. I've looked at John McHale's work. It's very good. I also suggest Rob Nadelson's work, that you could go anything from a kind of perk. A perk was a kind of situation, salary, all the way to any benefit. And therefore, we need to look at the context of the Constitution and try and figure out if any benefit whatsoever is a good way to read the clause in context of the rest of the Constitution. One thing I want to point out on that is in 1810, there was a possible, it would have been the 13th Amendment to the U.S. Constitution that failed ratification by 2 states, approved by both houses of Congress, that would have applied basically the exact same language of the Emoluments Clause to the citizens of the United States. So therefore, we would not have been able to take emoluments from foreign states. And so if that means that someone who ran a tobacco shop sold some tobacco to the French diplomat was going to be stripped of his citizenship because it was an emolument, that seems a little bit extreme of that was the understanding of the time if it was the same understanding that's being argued up here.
Yeah, thank you. And the point of the OLC memos and other ways that this has been brought up to date is that this is, we're casting it as a relic, but it's very relevant in terms of what's happened in prior administrations. And it does occur to me, just before, we're going to open it up to questions, but given some of these competing theories, I'm wondering if some judges, and I'm thinking about the Supreme Court if it ever would come to it, might find it more comfortable just to get rid of it on standing. Why don't we just at least lay out as quickly, why don't you lay out as quickly as possible, Trevor, just the counter on standing very quickly, and then we're going to open it up.
Oh, well, it depends on which one you're talking. I mean, since everyone's trying to get standing in different ways.
Let's start with the crew one.
The crew one is interesting. So, I mean, we have an issue of this sort of competitive harm element that they're being outcompeted by going to the Trump Plaza. Now, this is interesting because on one level, I mean, it's a generalized grievance. And it's hard to rectify. It would be hard to say, for example, if you were purchasing Barack Obama's book to read it to get favor from him, and then other authors said, that is hurting my book sales. But you were subjectively doing it in order to curry favor. That would be a very strange argument of the kind of injury that you'd be getting. There's also arguments that it's not even justiciable in its own way. There's an argument that it's actually committed to Congress, that it's textually committed to a branch because it has the consent of Congress for Congress to decide these issues. That would be a Baker and Carr. And there's also a basic problem that the case that is being relied upon, the Hovens case, was actually about damages, and this is about an injunction. And this is a very different type of standing, because as Josh Blackman had written on the Crew case, some of this stuff before they brought in was the damages are self-inflicted. But basically, we're going out to try and fight this because we're trying to fight this thing, that's the damage that we have. Like, because we're trying to fight the ethical violations, that then we're shooting ourselves in the foot, and there's the damage that you should bring back. So the self-inflicted part is a really difficult part with a lot of these. I hadn't actually, the Maryland one, I had not heard yet. I really want to look at that, because the one you said about their constitution had an emoluments clause, that's a fascinating argument. I'll have to think about that one. But yeah, generally speaking, I think standing is going to be as big a problem for these cases as any problem of the definition of emoluments.
Yeah, and Breon made the good point that Congress has a responsibility here, and that may eventually be hard to defeat. When is what schedule are you on for your case?
Yeah, so the administration has until September 15th to file a motion to dismiss, and then we'll be responding to that in late October. And I'd push back a little against the idea that just because these are difficult questions, or I should say at least unprecedented questions about the scope of the term emolument, that courts are going to be looking for some way out. I mean, the fact is the courts have an important responsibility. They're an independent third branch, because they're supposed to be a check on illegal action by the executive branch. And the fact that, this clause hasn't been interpreted before doesn't mean that I think that they're going to try to shirk away from what's really their responsibility under the Constitution to give meaning to this constitutional text, and again, to check illegal action by the executive.
I think that's a good point, and I think that it goes to where these cases were filed. I'm just thinking of when we get to the Supreme Court, and if we ever get to it. So let's hear what kinds of questions you all might have at this point. Yeah.
Question for Trevor. Wondering what you think would count as emoluments. What are the criteria for transactions that would count as emoluments?
Yeah, I listed one. Like, if you got a position, I mean, if you were consulting for the questions that have been raised for different officers under the United States, or can someone who works at the Department of Energy go and do a consulting gig for that? It has to be a discharge of duties related to the office. And on the very extreme positions, the emoluments are only created by Congress on one level. So if a foreign government decides to pay Donald Trump to do some sort of job, I mean, it's the same. Think about it in the domestic emoluments clause case, with none of the states can also pay the president something, like pursuant to him doing his job, because that would be bad, which I agree, and that only applies to the president, and it's textually committed to the president. So it's that kind of sort of salary in exchange is, I think, the best reading of it.
So in your view, if a state said, we could say that we're paying you this money for doing your job, but we're not going to say that, we're just giving you this money, that would be permissible under the domestic emoluments clause in your view?
No, I think it's an objective test. I mean, you take into account, but if it is clear that they are being paid to discharge the duties of an officer position related to the office, then that's getting to closer to what an emolument actually is. But as I said, there are multiple possible definitions. Like perquisites for office is also one that is often used. I can give you, for example, a definition. In cases, is written down here, in cases that had to deal with it in other contexts. So, for example, in a case called Hoyt, the court defined it as an emolument as embracing every species of compensation or pecuniary profit derived from a discharge of the duties of the office. In a case called McLean from 1912, they said that emoluments are but expressions of value used to give complete and recompense to a deserving officer. And then in another case called Hill, a sum collected by a clerk for a service not pertaining to his office was not a fee or emolument. For a service that was not pertaining to the office. So people are trying to say that, like, state-owned media running episodes of The Apprentice and then giving money to Donald Trump for royalties on that is not related to the office or for discharge of duties. So that sort of thing.
The key is that it's related to his...
Yeah, and related to the discharge of duties, yeah.
Gotham,
But there is this other definition that can be any benefit. I just think, and it's contemporary. I just think that it gets crazy if you interpret it to say any benefit. I mean, things get really nuts.
Gotham, did you have anything you wanted to add to that one?
Yeah, I think I would point out that one of the texts that the president's supporters here, or at least the people arguing in support, excuse me, the people arguing against the Crew suit, for instance. I think one of the texts that they fall back on is a document that Alexander Hamilton wrote that says pertains to the compensation of officers under the United States, and the manuscript version of this at the National Archives does not include the president. And this has been used as evidence that therefore the president is not in office under the United States. Now the problem is that when the document is printed and put in this volume of government documents called the American State Papers, the president is included. There's a sort of arcane argument about, some random clerk did it and therefore it shouldn't matter, which I don't really, that would make a whole lot of government documents not unimportant. But if you go then and look at how the Treasury is dealing with who's an officer under the United States for the next many, many, many years, the president's always there. Compensation is listed just like some random customs officer in North Carolina or revenue officer. So I just don't think that that argument, from a historical perspective, has much to it.
Thank you. Yeah.
From my past experience working in government ethics, I can tell you that the Emoluments Clause is not obscure whatsoever. Anybody working in government ethics has heard of the Emoluments Clause, have had to consult on the Emoluments Clause. Employees have outside activities, it comes up. But my question is, and I'm confused about the Foreign Gifts and Decorations Act and the Emoluments Clause. Isn't there a de minimis amount that a president can accept, like $300, maybe it's $395, but anything above that has to be reported or turned over to the government? Am I confusing that with?
No, that's essentially right. So
Yeah.
Congress, as part of its oversight role into what benefits federal officials can accept from foreign governments, has passed the Foreign Gifts and Decorations Act, which does allow certain benefits to be accepted if it's of de minimis value, or if not accepting it would cause embarrassment. I mean, the problem here is that the president is accepting all manner of benefits that don't fall within the Foreign Gifts and Decorations Act, and he's not coming to Congress and disclosing those and seeking consent. To my knowledge, he has not, but I'll...
Yeah, I have not heard of him having disclosed this, and I think the big conflicts here are not concerning things that would fall within the Foreign Gifts Act, because they stem from his business dealings, not from here's a jade Chinese horse or something.
And that's, by the way, the business dealings are difficult too, because there has to be some sort of piercing the corporate veil here. And if you have a theory that, and we do this in corporate law, we say a payment that goes from A to B to C, if A is the government of Qatar, B is Trump Tower Hotel, and C is Donald Trump, can we construe that as a payment from A to C? And that's a difficult question too, and which I think will also be explored if we get there.
Right there. Yeah.
So I'm probably one of the few lay people in the room, and I don't want to derail this or waste your time. 2 comments. There are many public citizens group like Indivisible Montgomery, which I'm part of, who are keenly interested in emoluments and do not think of it as a technicality. That's just kind of an FYI, court of public opinion. But my question is, and this is a layperson's question, you don't have to answer it today, but maybe it would be good to answer it in public publications, is when you hear a statement that says that the Department of Justice is proposing that the emolument suit be dropped. The natural layperson's question is, well, if taxpayer money is being used to defend Donald Trump, and it looks to us as personally defending Donald Trump, is that in and of itself not taking advantage, and maybe it wouldn't be emoluments, but taking advantage to support his personal positions? That probably makes no sense, but there are a lot of people.
Go ahead, Stephanie.
So what I think all of the litigants here have done is we filed these lawsuits as official capacity lawsuits. So when you have a government actor, you can sue them as either an individual in their personal capacity, or you can sue them in their official capacity. Because the emoluments clauses are specific to the domestic emoluments clauses solely about the president, and despite the debate here, what we are arguing is that the foreign emoluments clause applies to the president because of the president's office. These are official lawsuits, and an official capacity lawsuit is properly defended by the Department of Justice. That's one of the things that the Department of Justice does.
That said, I mean, I do think it is, and I think this is maybe what your question is getting to, it is unfortunate that the Department of Justice and taxpayer resources are being spent to make these extreme arguments about the president's ability to put his business interests ahead of what he should have, which is undivided loyalty to the American people.
I would push back on saying that's extreme, but I mean, the Seth Barrett Tillman's work, which changed the game a lot, and I do suggest going to the National Constitution Center website and read the exchange between Zephyr Teachout and Seth Barrett Tillman, and then the thing they wrote together where they both agree it is a very difficult question about whether or not the Emoluments Clause applies to the president, but he wrote that in 2008. I mean, that was a scholarly paper originally. It wasn't just sort of this extreme thing that he created for the purposes of defending Donald Trump.
Okay, yeah. Here first. Yeah.
I had a follow-up on the personal although the Emoluments Clause clearly refers to the president because he is president, I would think that it would be the reverse, that you're suing him in his personal capacity because he's accepting money for his own personal gain from his own private interests that the Constitution prohibits him from doing. But the acceptance of the money is in his private capacity. And if you were to pursue that route, the argument would be that justice shouldn't be involved in the case at all.
Well, I think the idea is that it corrupts the official duties of the office. So, I mean, you can personally gain from this, but since they did sue in the official capacity, but it is a concern about corrupting the duties of the president in the public trust. That is, so in that sense, it's the corruption of the office. So it's an official capacity. Otherwise, it'd be like just personal bribery. You know, just like I took this, so I got a bribe in return.
Yeah, it's the official corruption that is the worry here. Yes, back there. Yeah.
I assume there are a few lawyers here, and some of them may even be government lawyers. Have any of the issues that you have either raised already or haven't raised reflected both the fact that there's already been one ethical case filed by, I think, 20-odd law professors against a lawyer in the government in the D.C., and the fact that the head of the Office of Government Ethics, who was a lawyer, has resigned based on his feelings about what he is required to do and is not apparently being permitted to do. Is there any ethical question for the government lawyers who are handling these cases?
I mean, just the Emolument Clause cases, or any of the cases? I'm very deeply concerned about President Trump's business interests and how they're affecting his decision-making, and that he should divest himself and put it into I think that should have been the case to begin with. And I think we should be constantly watching at what's going on there, because I think there's a lot of stuff that we should be concerned about. In this context, I don't think they're Emoluments Clause violations. They're violations of maybe a bunch of other things in addition to decency. But in this one, so I don't know, in terms of all the ethics things and all the government ethics problems, it's something we should pay attention to, yes.
Yes.
I have a question sort of getting back to what we were just talking about.
Right up in front here first.
There is a lawsuit is suing the president in his personal capacity in D.C. It alleges unfair competition under common law tort that's brought by a restaurant here in D.C. and basically says that the Trump Hotel, the old post office hotel, competes unfairly with businesses in D.C. So I'm curious just sort of because it's not an emoluments case, but it does sort of get to the question that she asked and this whole thing. So I'm just kind of curious your thoughts on that lawsuit and sort of the kind of teeth it has, not to make you opine on someone else's litigation, but I'm just curious.
Stephanie, do you want to jump in on that one?
Well, I definitely don't want to kind of set forth a opinion on the kind of the nitty-gritty of the litigation, but it is different than ours because it is not an emolument suit. I mean, I think that some of the arguments have similarities because it really does go to kind of this anti-competitive marketplace that has been created. So, they're looking at it from the kind of very micro perspective, looking at it from their personal business and how their personal business is affected by having this hotel with a large restaurant that is, they're arguing taking business away from their business. But there is a similarity there to what we are arguing in our lawsuit, where we are saying that, we have an interest in protecting generally the residents, the workers within the District of Columbia, within the state of Maryland, who work in these industries, who are affected by this same anti-competitive marketplace that has been created by the existence of the Trump Hotel. If these blinds were open, I'm guessing, I don't know which direction we're facing it, but we'd be able to see it right from this window. And so I think that there are some definite similarities there. It is different in that it's not an Emoluments Clause claim, it's an unfair competition claim, and so it will proceed differently. But I think that there are definite similarities in some of the arguments being made.
On that score, I just want to ask, we've already had one amended complaint, and with the kind of way that these are going to evolve over several months, Brianne, do you anticipate that we'll have more amendments given amended claims here, given what we might see President Trump's businesses as they evolve?
Sure. Well, as I mentioned, we'll be amending our complaint next month to add additional congressional plaintiffs and also to update the factual allegations. As Joan mentioned, every day there are news stories about potential violations of the Emoluments Clause. Since we filed, there have been an additional Chinese trademark granted. There have been other developments, and so we will reflect that in our complaint. I could imagine, I won't speak for any of the other folks up here, but there could be additional amendments. But again, I just want to highlight, as fantastic as the media has been and the public reporting has been uncovering some of the benefits the president's accepting from foreign governments, the fact is the lack of transparency around his business holdings, both here and around the world, means that it's really impossible to know about all of the benefits that he is accepting or might be accepting. And that's why, judicial action is so important. The clause has a structure. It says, if you want to accept these benefits, go to Congress, disclose them, seek consent. The president isn't doing that, and that's why the courts need to get involved so that we can find out what's going on and make sure the president complies with the Constitution.
I think we've time for like 2 more questions. You in the back? Sir? Yeah.
So this is actually a question for Mr. Burris regarding the amendment that you mentioned earlier that was not passed because it didn't reach enough states. So in bringing that up, then doesn't that run counter to your argument that they're about using the standards of the time in which the Emoluments Clause was written? And this is actually a multi-part one. Okay. Sorry. Because if it doesn't, then I also have a question for that, though. So doesn't it run counter to the standards of the Emoluments Clause was written? And if it doesn't run counter to that, then doesn't that then suggest that there was indeed a general concern for fighting corruption, which you would also push back against?
Thank you. Good. So there was a concern for fighting corruption. I said that absolutely, it's a huge part of the Constitutional Convention, and there was a concern. I was pushing back against saying that we should interpret broad swaths of the Constitution, and I've done this in the campaign finance realm, just on the anti-corruption principle, and other principles were important too, that they were for. In terms of the would-be 13th Amendment, that's 1810. So it depends on how you sort of do your originalism, and often you do have the race for the oldest dictionary kind of method of doing originalism. We do have a lot of sources that back up. If you stopped your originalism if you're a really hardcore originalist, you'd stop it on May 29th, 1790, which is the day that Rhode Island was the 13th state to ratify the Constitution, and everything after that is not a relevant consideration. The reason I brought it up is that if the Emoluments Clause is properly read to be as broad as is being argued in these cases, then when they took the exact same clause and they wanted to apply it to every citizen of the United States, then that would have meant that to merely receive any benefit from a foreign government whatsoever for individual citizens would have stripped them of their citizenship. And I used it as an argument ad absurdum, like it's a slippery slope argument to say that that's an absurd result. That's not what they would have thought, using the exact same language of the Emoluments Clause to apply it to normal citizens. And so therefore, they must have thought emoluments meant something more specific than any benefit derived from a foreign government.
Yeah, we'll let Gotham come in here because I think he'll back up what you're pursuing.
Did I answer your question, or did I miss something about?
But also, like, I'm not going to say that it's not a slippery slope, but if it if I feel like I might be losing this, but if it's whether or not it is a slippery slope argument, the fact that they did try it twice does then suggest that there was, with again the exact same language.
You mean that they would have wanted no citizen to get any benefit? That's how concerned they were about corruption? Is that what you're arguing? That they believed that emolument meant any benefit, and therefore they were so concerned about it that if you ran a tobacco shop in Philadelphia and the French diplomat came in and wanted to buy some tobacco from you, you had to tell them to get out? Is that what you're saying?
Not quite, but
okay.
Okay, so it sounds like it's close to Gotham. You probably can respond to the gentleman's point here.
The point I'll make, two points on the 1810 amendment. A, it fails, so it's not adopted. Doesn't matter, still fails.
Yeah, right.
Would be, I think, fairly important here. And the other point is, if you look at the legislative context of this era, it is war. It is, the United States is planning to go to war. It has been through a very tumultuous decade of struggle with Napoleon, with Great Britain. And if you could just suspend belief for a moment and imagine that tomorrow Congress passed a law that cut off all American commerce with the rest of the world, basically, and said, you can't trade with anyone because we're trying to teach them a lesson about not to mess with America. Well, that's what Thomas Jefferson did in 1808. That's what James Madison all kind of did in 1809. 1810, there's another version of this. So it's not like extreme legislative solutions were not on the agenda at this time period. This is the embargo policies I'm talking about. I would also say that, in the context of war, receiving a gift, a title, an emolument from a foreign state becomes something very different than the ordinary stream of commerce that it might occur in. So that context, I think, is very important for the failed amendment.
We're out of time, but let me just say this, since we're at the first chapter of what's going to unfold over probably another year or two. Watch in early August when we get the response from Crew in its case, and then eventually we'll have the historian's brief in that one. Late September, we'll have the response from the Justice Department in the members of Congress case. And what, Stephanie, is there next?
September 29th.
Okay, great. Thank you all for attending. We appreciate it. Thanks to ACS.